Imagine spending months or even years building that innovative tech product or technology, whether it's a software or a hardware, only to wake up one day and find someone else copying it, selling it, or profiting off of your hard work. This happens every day to founders who do not take appropriate care to protect their intellectual property. In this video, I'm going to show you how you can protect your intellectual property, how you can identify it, and how you can profit off of it, whether or not it's completely ready yet. Hi, I'm Norma Grace, a corporate and tech lawyer passionate about helping founders like you start, grow, and scale their businesses, their intellectual property, and their technology. And I do all that by protecting your business, your IP, and your technology, and your future. If you're building or you have an existing tech product and you have not taken appropriate steps to protect it, or you are not even monetizing it, then you are leaving opportunities and money on the table. And in 2025, we are not doing that. So by the end of this video, you'll know why intellectual property protection is crucial for your business, the 4 pillars of intellectual property protection for your tech product, IP strategies to implement regardless of the type of intellectual property you own, intellectual property mistakes that you should definitely avoid, and how to monetize your intellectual property. Come on, let's dive right in. First off, what is intellectual property and why is its protection critical for your tech products? Intellectual property, or IP for short, are creations of the mind. For instance, your literary or your artistic works, your designs, your names, your logos, slogans, colors, etc. Specifically for your tech products, they are your algorithms, your softwares, your hardware, your source code, your technical know-how, your UI designs, and so much more. Intellectual property is not just a legal concept. It is one of the most valuable assets that your tech company can own. And when you do not take adequate steps to protect it, you risk copycats selling your intellectual property, competitors registering your brand name, or even copying your business model or any other tech product that you have, investors hesitating to invest in your tech product because your intellectual property protection is weak, and so many other reasons. Now, as you can clearly see, intellectual property is more than just an idea. It is what gives you a competitive advantage in the market. Now, for your tech products, what are the pillars of intellectual property? What tools can you use to protect your intellectual property? There are 4 of them, and they are patent, copyright, trademark, and trade secrets. Copyrights protect original works of authorship fixed in a tangible form of expression, and it grants the owner of that copyright exclusive rights to use, copy, and derive other works from the original while preventing others from doing the same. So copyright protection covers your softwares, your source code, your UI designs, your algorithms, and your AI generated works, although that one is highly controversial, so we wouldn't really go into it in this video. To protect your intellectual property using copyright, you need to do the following. Number 1, register it. Now, copyright vests automatically, yes, but to enjoy that exclusivity, to enjoy the backing of the law, you need to actually register it. Second thing is you need to include watermarks, copyright watermarks on your documents or on whatever it is that copyright protection is covering. You need to include the copyright watermark on it. Third, and this one is optional, you can implement some technical protections. So for instance, you can encrypt that work. You can use digital rights management techniques to protect that work. 4, if you're going to be working with developers or freelancers or even employees, then you need to have an intellectual property protection clause in your agreement with them, stating the ownership rights and the obligations of whomever is going to be working or adding to or otherwise improving that intellectual property. In Nigeria, you can actually register your intellectual property online by yourself without the need for any agent, but it's advisable to have one, especially if you've never done it before and if you don't know how to go about it. If you want to register your copyright online in Nigeria, the portal is called the Nigerian Copyright E-Registration Systems. The link is, right here. But if you would rather visit their office, you can go to any Nigerian Copyright Commission office and visit it. And copyright in Nigeria is all regulated by the Copyright Act. As unique to your brand, your service, or your product, and it covers things like your name, your colors, your slogan, audio visuals, or anything really that distinguishes your brand from others in the market. To protect your trademark or your brand's unique identifiers, you need to run a search to make sure that that name, slogan, color, audiovisual, or whatever is not already in use. You need to then register your trademark under the appropriate class with the appropriate registry. If you plan to scale your business or expand into other countries, then you need to ensure that your intellectual property or your trademark is protected in those countries that you are scaling into. And then you also need to regularly monitor the market for intellectual property infringement and stop them on their tracks before they go out of hand. You can also trademark your domain name, your social media handles, your product name, and any other kind of name you want to trademark, really. It's not just your brand or your company name that is trademarkable. In Nigeria as well, you can register your trademark online but with an accredited agent, which is either a lawyer or someone who works in the registry and is accredited as well. The appropriate registry to register your trademark in Nigeria is called the Trademark, Patents and Design Registry, which operates under the Commercial Law Department of the Federal Ministry of Industry, Trade and Investment. And it is all regulated by the Trademark Act. Patents, on the other hand, protects new inventions and it grants the owner exclusive rights to use and commercialize that invention, but for a certain period. It covers new inventions, processes, designs, and other technological breakthroughs. For examples, your softwares, your algorithms, your hardware, AI, your machine learning systems, and any other new invention that brings a new way of either solving something or looking at something. So either a utility patent or a design patent. Basically, any new invention or process that changes the way something functions or it looks, or it even gives a new way for something to function and look, can be protected under patent. To protect your tech product under patent, you need to do the following. Number one, conduct a patent search to ensure that that thing you want to protect isn't already protected and in use by someone else. Two, keep detailed, very detailed records of your invention process. So anything from your black white notes to your sketches to your prototypes, anything basically that aided or that you use throughout your invention process, you need to keep notes or proper records of it. This will aid your patent application. File a provisional patent application to enable you secure an early filing date while you work or you refine your invention. Hire an IP or a patent lawyer to help you fine-tune and appropriately apply for your patent protection so that you don't go doing it by yourself and wasting time when you could have easily asked an expert to do it for you. And please, do not publicize your patent or your invention before you have sought protection for it, because once you have publicized it, it makes it ineligible for patent protection. To register your patent in Nigeria, you need to submit an application to the Nigerian Patent Office, which works under the Trademark, Patent and Designs Registry in the Commercial Law Department of the Federal Ministry of Industry, Trade and Investment in Nigeria. It is all guided and regulated by the Patent and Design Act of Nigeria. The last IP pillar is trade secrets, and these ones protect your confidential business information. Basically, any information that gives your company or your business a competitive advantage in the market. And trade secrets only cover as long as that information remains a secret. Once it becomes public information, trade secrets ceases to apply. And if you want trade secrets to apply for that particular information, then you need to ensure that all of your agreements, all of your interactions or engagements with third parties are covered under a non-disclosure or a confidentiality agreement. As of right now, there is no unified legislative protection for trade secrets. So you need to take appropriate steps actively by yourself to protect your trade secrets to avoid them becoming general information. You also need to ensure that information is shared with trusted people on a need-to-know basis only, because the fewer people know, the better for you. Here's a pro tip for you. If your tech product or its advantage is more in execution rather than pure invention, then trade secrets might be a better way for you to protect it rather than a patent, because patent risks disclosure. For example, Google's search algorithm is protected as a trade secret, not as a patent, because if it's a patent, then it would have to be disclosed, which will then lead other people to kind of like licensing it off of Google to be able to implement search. And Google doesn't really want that. So they protected their search algorithm under a trade secret rather than a patent. Now that you know the 4 legal pillars under which you can protect your intellectual property, What are the steps or what are the IP protection strategies that you can use regardless of the type of intellectual property you own? The first thing is to beware of collaborations, partnerships, joint ventures, or any other kind of legal agreement that happens before you secure in your intellectual property protection. Because if the idea eventually becomes successful, disputes can arise as to who exactly owns the IP, especially if these partners worked on it in some way, added to it, removed from it, improved it, or otherwise tampered with it in any way. You need to keep adequate records of where the ideas came from. You need to have conversations on who owns what, and you need to have all of these responsibilities, obligations, rights, benefits encoded in an agreement to protect you moving forward, to protect the integrity of that idea, and to protect the idea in general. The second thing you need to do is that you need to ensure that you have cybersecurity measures in place to protect the IP from being stolen or from being leaked or from otherwise being tampered with without your active knowledge. Number three, you need to understand and adhere to international intellectual property rules, especially if you plan to scale that product or especially if you plan to enter into and operate that intellectual property in another country. Four, you need to recognize that your intellectual property is an asset and you need to treat it as such. To treat it as such, you need to then protect it and prevent others from infringing on it or from otherwise using it without your express permission. Five, you need to strategize the protection or the timing for the protection of your intellectual property with an expert, because in most countries, if you publicize your intellectual property before it's been protected, you cease or you automatically become ineligible for that protection. For instance, if you publicize your patent before it is being protected or before you file for a provisional patent application, you automatically make that invention ineligible for protection because it is now public knowledge. Six, you need to be careful with open source software applications or codes or whatever. Anything that is open source, you need to be very careful with it, because while it's good or it's a good base for you to build your tech product, also need to be mindful that open source softwares come with their own hidden terms and conditions so that you don't inadvertently infringe on one of the terms and conditions, and also to protect yourself so that if the owners of that open source software change the terms and the conditions one day, you are able to first of all know what the changes are, how to implement them so that they don't affect or greatly affect your tech product. Number seven, or strategy number seven, if a developer, an employee, a freelancer, or anyone else contributed to the growth of that intellectual property in one way or the other, then you need to make sure that the ownership stakes or the conversations about ownership stakes are had and it's encoded in an agreement. And you need to pay them adequate compensation for their work in making that intellectual property become what it is. Because if you do not pay them an adequate compensation for it, then they have a stake to that intellectual property. Strategy number 8, if you created the intellectual property as an individual, you need to figure out whether or not you want to retain personal ownership of it, that is owning it as your person, or you want to transfer ownership to your company. There are both sides to it. If you retain personal ownership of the intellectual property, then good for you. You own all the rights and all the benefits and all the consequences of owning that intellectual property. It is yours in your person, in your personal name. But if you transfer ownership to a company, then that means that it ceases to be your property alone. It's now the property of every single person that has a stake or a share in that company. You're no longer the sole owner of that intellectual property. And you know what that means. You can be bought out of it. You can be, booted out, which is like the bad parts. The risks and the benefits are shared equally amongst all the owners of that company. And your ownership will be limited to your equity stake in that company. So you need to discuss this. If you own it and you're thinking about transferring it to a company, you need to discuss this fully with your lawyer. But on the other hand, if you own the company fully, then that's not really an issue, especially if you're not really planning to scale or any other thing like that. Or another thing that you can do is you can register a company which you own fully, transfer rights to that IP to that particular company that you own fully, and then that company can then license out the IP to other companies, whether or not you are a member in that company. So that's another thing that you can do. In fact, I have a step-by-step intellectual property strategy checklist for tech companies, startups, SMEs, and businesses alike. It's a free resource, and the link is in the description below. So do well to get it and make sure that you have all the items ticked off. I will credit the World Intellectual Property Organization for the idea to do that. So by now, you have a strong idea of IP protection strategies, the 4 pillars of IP protection, the mistakes to avoid, and how to monetize your intellectual property. But how do you enforce them exactly? What do you do when someone steals your IP or copies your IP? How do you legally enforce your rights? Well, in my next video, I'm going to talk about exactly that, answering the question of how to legally protect your intellectual property, how to fight your IP infringement battles and win them the right way. So what do you have to do? Subscribe, stay updated, and I'll see you in my next video. Bye!